not agree with the decision of the Speaker and criticize. It is a principle of open democracy.
All right. So the capture of Parliament by executive description is
does
misplaced.
not exist because there is nowhere. I don't see.
Okay.
Those are political expediency statements.
In your submission, Bwana Opiyo Wandayi has gone through the Daily Nation and is now to the next paper. So I guess you've been talking for quite a while.
Yes.
Bwana Opiyo Wandayi, the decision, of course, is something you don't agree with, but the Speaker says it is not appealable. It stands. Does this mean you will continue as minority leader, or is there any action that you are going to take, or this is water under the bridge?
Mark, thank you. At least by taking the much time you took, Senator Chirarigei has enabled me to go through the newspapers. Yeah, I'm now a little bit more informed
Yes.
than when I came. That aside, Mark, a number of issues have been raised. I wouldn't ordinarily want to go back to the happenings in the National Assembly last week, prior to and after the ruling by the Speaker, for two reasons. One is that we have canvassed those issues for long enough, both sides. But more importantly, I am aware that the Azimio la Umoja coalition party is considering seeking legal redress.
Okay.
Yes, on the ruling by the Speaker of the National Assembly on the matter of the majority and the minority coalition parties. And therefore, I wouldn't want to delve so much into the merits or demerits. But having said that, it's important for me to put some issues in context. It's very important now that I'm here.
Yes.
Yeah.
Go ahead.
With you and before the public.
Yes.
A number of untruths have been said by my colleague, who I highly respect, Senator Chirarigei. And let me start from where he left. You know, Mark, this country is governed by the rule of law. And the Constitution is the supreme law of the land. The Constitution itself sets out how statutes or ordinary laws are to be enacted, okay, amended, or repealed, for that matter. Yeah, and therefore, it is not right, not proper indeed, for one to rubbish outrightly a statute law which is in existence, such as the Political Parties Act, in the manner both the Speaker and now my friend here have attempted to do. As we speak, the Political Parties Act, as indeed amended last time in February this year, is still law. No court of law has declared it unconstitutional. Yes. And therefore we have to live with it. And it provides very clearly, yes, very clearly how political parties are to be formed and managed. Okay, it is the same law that has created, okay, a situation where a political party can function both as a political party and as a coalition of political parties. That is the law. Nobody has challenged it and succeeded, yes, in the court of law as is required. Secondly, a lot has been said about the right, the freedom of association as provided under Article 36 of the Constitution. I also had talk about freedom of political choices, the right to make political choices as enshrined under Article 38 of the Constitution. Fair enough. We all enjoy those rights.
Yes.
And we must protect them jealously. You know, they are rights that we attained after a very long struggle, a struggle that left many people maimed.
Yes.
Others lost their lives, you know.
But they come with consequences.
And others were jailed for it, like my party leader, yes, was jailed for a period of not less than 9 years. fighting for these rights that are now enshrined in the Constitution of Kenya 2010.
Okay.
But let me tell you, and this is the problem with reading a constitution selectively. Yeah, I always say that when you want to read a constitution, you must have a holistic reading of the constitution for you to come up with a proper interpretation. Okay? My brother here is a lawyer, and he should know this. Yes. That those freedoms and rights under the Bill of Rights, that is chapter 4 of the Constitution, have a caveat. Okay? There are situations where they can be limited, and that is expressly provided for under Article 24 of the Constitution. And why do I say this? Political parties that came together out of their own volition prior to the August 9 elections and formed the Azimio la Umoja coalition, about 26 of them, my party ODM being one of them, did so voluntarily in exercise of their right of association and right of political choices under those articles.
Those who left would argue they've left voluntarily as
well. Now, by signing to the Azimio coalition, those parties, again, without any form of duress or coercion, declared by themselves that having joined the Azimio la Umoja coalition, they would only be able to leave that coalition after 3 months after the election of 9th of August. That's the earliest they could leave, or could start the process of leaving, was 3 months after the 9th August. Okay? Now, when you turn around and start saying that you are being forced to stay in a relationship that you are unhappy with, and yet it is you who agreed to that relationship, together with these terms, now, who is fooling who? Okay? These same parties, let me also make it clear, because the public needs to know this. A number of them have tried to extricate themselves from the coalition agreement, the Azimio coalition agreement. I think that party of Mutua is called what? It's called Chap Chap.
Yes.
Chap Chap has tried. Another one has also tried, Think Pa, of Speaker Kingi. They have gone to the political parties dispute tribunal, which is a requirement of the law, that if you have issued a coalition or a political party, the first port of call is the political parties dispute tribunal. That tribunal has declined to grant them their prayers, to be allowed to leave the Azimio coalition.
Right.
They have gone, some of them have gone to the court, High Court. The courts have refused to allow them to live in the manner they are attempting to live, that they must go back and abide by the coalition agreement before they can formally leave the coalition. Now, what was happening in Parliament, unfortunately, in the National Assembly, is that people were attempting to invite the Speaker to grant what the courts have declined. People were going around the political parties dispute tribunal, which is a quasi-judicial body, you know, and the High Court have both declined to allow these parties to exit as a mini coalition in the manner they are attempting to do. And yet they go to the Speaker, asking the Speaker to declare that they can leave. So the Speaker, in making his ruling, of course, made a very serious error in law.
So you're saying Moses Wetangula, in effect, with his ruling, endorsed an illegality?
Totally.
All right.